Good day and welcome to Epstein Becker Green's webinar. Before we begin today's presentation, please be informed that today's webinar is being recorded and the participant phone lines will be placed on mute throughout the program. You are welcome to submit questions throughout the program by using the Q&A feature provided by WebEx, and at the end of the program, with time permitting, the speakers will address your questions. You are also welcome to submit questions directly to the presenters following the webinar, and contact information will be displayed at the end of the presentation. In approximately 2 to 3 business days following the webinar, we will communicate the availability of the webinar recording and access to the PowerPoint materials. We're pleased to have fantastic speakers today. At this time, I would like to turn the webinar over to Jeff Ruzal.
Good afternoon, everyone. Thanks so much for attending. Today, as you know, is the Industry Spotlights webinar series, Wage and Hour Developments within the Hospitality and Home Healthcare Industries. I'm joined by Nancy Popper and Shira Blank. Nancy, Shira, and I are going to be discussing some of the newest developments to look out for in wage and hour, focusing largely, as the title indicates, on hospitality and home healthcare, though much of the subject matter is applicable, generally speaking, with regard to industries outside of hospitality and home healthcare to other client industries. Nancy is going to kick off today's presentation with information of the regulations under New York, specifically focusing on the hospitality wage order requirements, as well as spread of hours requirement under New York law, as well as call-in pay requirements, perform maintenance pay, and best practices for tracking hours and record keeping. Shira is going to focus on the home health care issues under the FLSA and New York law, including issues such as sleep time and 24-hour shifts. And I'm going to be discussing tip pooling and sharing, surcharge issues, and independent contractor classification. So without further ado, I'd like to turn it over to Nancy, who's going to discuss the hospitality wage order and its requirements.
Thanks, Jeff. Thanks for joining us today. As Jeff mentioned, I'm going to be speaking today a little bit about the hospitality industry wage order. Just to back it up a little bit, in New York State, like many other states across the U.S., the wage and hour laws are broken down into specific requirements based on the industry in which the person's working. This is done largely because the needs and requirements of different industries will dictate different requirements with respect to how people are paid and how employers should manage their workforce with respect to things like uniforms and scheduling time. So we're going to focus in on hospitality, but just so you know, there are several other wage orders in New York, including building services, a miscellaneous wage order, and there are a variety of other things to be mindful of when we are thinking about the specific industry that we're in. So we're going to talk a little bit about who's covered under this wage order. And what's great about this, the detailed regulations that are put out by the state is that they give us a lot of helpful guidance in order to determine who's actually covered by each one. So the hospitality wage order covers a variety of employees who are in the hospitality industry. And specifically, employees who are covered here are food service workers, and then non-service employees. And there's helpful definitions for us within each in order to be able to determine who is covered and when. So as the wage order defines, a food service worker is any employee who is primarily engaged in serving food or beverages and who also regularly receives tips. So this could include employees like wait staff, bartenders, captains, bus personnel, so someone who's bringing food to and from a table, but does not include delivery persons. So this is an area where sometimes people get a little bit tricked up, but delivery persons are not covered under a food service worker. A service employee is an employee who is other food service worker who customarily receives tips is covered under the hospitality wage order. And kind of a definition by not being a definition, a non-service worker is any other employee than a service employee or a food service worker. So a bit of a non-definition there. Within the hospitality industry, the wages, the minimum wages are a little bit different than what we see across the rest of the state, and certainly different than what we see under federal law. So under federal law, minimum wage for all employees is $7.25 per hour, and this has been the same since 2009. Now, when we're talking about exempt employees, the rate pay and for the salary exempt threshold is something that has not changed, was supposed to be changed several years ago, and is now undergoing discussions to be changed again. But today we're really going to focus on non-exempt employees within the hospitality industry. So New York State breaks down the minimum wage based on where the employee is working within the state. So in New York City, wages are a little bit higher at the moment, but the goal through legislation that was passed a couple of years ago is to eventually bring up all employees in the state to a $15 minimum wage. And something we've seen this trend in this movement over the past couple of years is bringing wages up, particularly in the hospitality and fast food industry. And we'll talk on the next slide about fast food wages, because within industry, there's really been a push through the Fight for 15 campaign to bring wages up a little bit higher. New York City, as you can see, currently the minimum wage for large employers, which is 11 or more employees, is $13, and for small employers, 10 or more employees, is $12 an hour. In Long Island and Westchester County, minimum wage is $11 an hour, and the rest of New York State is $10.40 per hour. The changes for New York State minimum wages go into effect on December 31st of every year, and that's different than what we see in a lot of other states, which have it be January 1st. So something to really be mindful of towards the end of the year, and if you have people working on New Year's Eve, this is a change that goes into effect on December 31st and not on January 1st. You can see from this chart that over the next few years, the minimum wage is continuing to increase every single year. So this is something to be mindful of every single year if you're paying minimum wage or somewhere close to it, to keep an eye out and see if any changes are necessary for your workforce. Finally, we're just going to touch on minimum wages for fast food workers. I mentioned due to the campaigns and the pushes for fast food workers to receive higher wages, in New York City, minimum wage for fast food workers is actually higher than for other employees within the hospitality industry. And currently it is $13.50 per hour, and then for the rest of the state, it is $11.75 per hour. And again, this is increasing over the years to eventually get to $15 an hour. We're talking about fast food employees. We're talking about those who are working, as you see in this definition, for fast food establishment, who are working customer service, cooking food, preparing food, delivery, security, things like that. So really important for you to understand what type of employer you are and how much you should be paying to your employees. So now that we've gotten a bit of an intro on the hospitality wage order and the minimum wage provisions, I'm going to pass it back to Jeff to talk a little bit about tip pooling and tip sharing.
Thanks, Nancy. And just to be clear, the actual title or header of that slide is tip pooling, tip sharing. It should also be tip credit. It's all things tip-related issues under New York law. Before we jump into that, though, I just wanted to add on to the very useful, helpful information which Nancy provided, which is, the hospitality wage order in New York is is a very comprehensive document, but it's not always particularly clear how it's constructed and how it's interpreted. Therefore, it's always very, very important when trying to read it and interpret it to work with outside counsel or internal counsel to ensure that what is being interpreted based on the print of the hospitality industry regulations themselves are how the New York State Department of Labor and the courts actually interpret the document. And for example, the New York State Department of Labor issued on it or provides on its website counsel opinion letters dating back a number of years, but are still quite helpful with respect to providing interpretive guidance based on, among other things, the hospitality industry wage order or the regulations as we refer to them. And so be mindful sometimes of that absence of clarity and try, if you can, to ensure that it's not based on your best interpretation, which may very well be quite reasonable, but also giving some sort of internal deference when interpreting it to how the Department of Labor looks at the issue, because ultimately, if there's ever a compliance issue, that's one of the if not best source to rely on that, of course, and court-made decisions. The other point I want to make, and Nancy had indicated that the 15 movement really is not only just a New York issue, but something that's taken foothold nationwide. Governor Cuomo in New York has made it quite clear that 15 is the goal. He's also indicated how he wants to move away from tip credits and really try to find sort of parity among all the various non-exempt wages, because there's been that push in the hospitality industry. There are servers and those who otherwise could qualify for a tip credit, which I'm going to explain in a few moments, are not necessarily treated fairly, or at least as the argument goes, and that rather there should be sort of that equal pay regardless of what the occupation is. So starting off with conceptually tip pooling and tip sharing, this all starts with individuals who otherwise considered tipped employees. And a tipped employee is someone who regularly and customarily receives tips. There's federal standard as well as the New York standard. The number or the threshold is $30 a week. Tips, not very much. If you're talking about individuals who work in the front of the house, servers, perhaps bussers, perhaps maitre d', or hosts and hostesses, and bartenders, perhaps barbacks, those customer-facing positions where gratuity could be left by a patron for the employee. Those are the individuals who qualify to share in tips, whether it's through a pool or a sharing relationship between and among employees. And those are the same employees who potentially qualify for a tip credit, which, again, I'll be explaining momentarily. Tip pooling is the practice where those directly tipped employees, which is to say those who receive tips from a customer in the food and beverage establishment, will pool their tips, often mandated through the employer, but doesn't necessarily have to be, and then there will be a distribution from the pool back out to all of those individuals who customarily and regularly get tipped. It could be those who are directly tipped by patrons of the restaurant and those who are indirectly tipped. For example, a server is often directly tipped, and a busser is not, though they would still often qualify. Sharing is a comparable practice, but that's where a directly tipped employee provides a portion of her tips to another food service worker or service employee who participates in providing service to the customers. It's important to note, and Nancy had briefly touched on this earlier, that hospitality wage order defines what a food service worker and service worker are so that you can determine what that occupation actually qualifies under, because that in turn determine what certain tip rates apply, which again will going to be discussed shortly. There's a table in the slides which set that out. Turning to the next slide. Tip employees can agree to pool their tips on a voluntary basis, and employers may also mandate, as I had mentioned before, a tip pool in an involuntary manner, in the sense that the employer can define how the tips are going to be redistributed after they leave the pool, meaning a directly tipped employee puts in $100 in tips for the evening and potentially comes away with less based on those other indirectly tipped employees with whom that directly tipped employee has to share tips. Only food service workers may receive distributions from the tip pool. That means back of the house employees, those who are not customer facing and those that do not fall under the definition of ones who are food service workers, may not receive a distribution from the tip pool. Similarly, management and employers may not receive distribution from the tip pool. And in addition to that, corporations employees alone must handle those transactions, meaning the pooling distribution goes to them from them. The employer can set the pooling regulations, percentages of each, but the employees themselves who should be involved in the actual logistics and process of distributing the tips to one another. This is a safe way of doing things for an employer to avoid potential allegations that the employer wrongfully maintained portions of food service employee tips that should have been distributed to them, and as opposed to the employer wrongfully maintaining them or perhaps sharing it with non-food service workers, so back of the house or management. So it is sort of protective in that regard. I mentioned before, those who are eligible to participate in a tip pool are those who are performing the personal service to those who are actually providing the tip, and that sort of makes common sense. I mean, it's those who are receiving the tips or potentially in a position who are performing this, whether it's not a server or a busser or a bartender, perhaps a barback, depending on what he or she does. It's service oriented and it's directly related to service to the customer, who should and who is mandated by the hospitality regulations a qualifier to share in the tip pool. It's important to point out, and this is sort of a consistent theme under New York law, and not just in the hospitality industry, but really across industries, across the wage order, whether it's miscellaneous wage order, which is really more of your catch-all, the building services industry, as Nancy pointed out earlier, or hospitality, that there are notice requirements which are very particular under New York law. With respect to the tip credit, we're turning to next, which again applies to those individuals who are front of the house, performing services, earning tips, who may have tip credit taken against their wages. That notice is important, and the employer is required to provide that notice. And it must be at the time of hire or before the person actually hired. A written notice must be given to the employer that there's going to be a tip credit, which is really an allowance toward the basic minimum wage. And we're going to get in a moment to the table on one of the slides in this presentation, which sets forth the different thresholds are, again, based on where the employer is located in the state of New York, the size of the employer, as to what the credit can be. I want to stress that notice must be written. Under the FLSA and federal regulations, the notice can be oral. It could be a bit relaxed in that regard, even though best practice really is to always provide a written notice, even if you're outside of New York. If you're a state where the FLSA applies and there are no other more employee protective laws or regulations in that state, the FLSA, I still think the best practice is to go forward with a written tip credit notice, just to be clear, everyone's on the same page, that employees understand at the outset of the relationship, the employment relationship, that a tip credit is actually going to be taken. The written notice under New York is very prescriptive. It requires the employee's regular hourly pay rate, the overtime hourly pay rate, the amount of tip credit to be taken from the minimum wage, the regular pay of the employee, and indication that that any extra pay is required if tips are insufficient to the employee up to the basic minimum hourly rate. That probably will not and should not happen if the employee is regularly serving customers and in a position to receive those tips, though it could. In some establishments where tipping may not be the norm, but it's regular enough that an employee typically qualifies from week to week to have a tip credit against his or her pay. But we want to ensure on a work week basis that the right credit is being taken, and that the employee with the credit and the gratuities being earned equals or exceeds the state threshold minimum wage, because otherwise there will be a violation, and that needs to be measured again on a work week basis. The employers are required to provide the notice in English or the employee's primary language. And that, like all other records under New York law, must be maintained for 6 years. 6 years is the statute of limitations under the New York labor law, which contains the wage and hour requirements in the state of New York. So where one can have a potential claim that goes back 6 years. Likewise, if there's a potential record-keeping violation, which will be enforced by the New York State Department of Labor, or if there's a potential tip notice violation or a tip notice issue, which would give rise to the question as to whether a tip credit was properly taken, 6 years is the magic number for purposes of record keeping. It's important to state that if notice isn't properly given, a tip credit cannot be taken. It's a highly technical violation, but one which can cause a lot of problems for hospitality employers, because in the absence of the notice, you do have a valid tip credit. And if you do not have a valid tip credit, you have a minimum wage violation, and you potentially have overtime wage violations as well. In addition to that, the penalties under New York law are quite punitive. There, of course, are liquidated damages, which exist under both the New York law and the Fair Labor Standards Act. Of course, liquidated damages under New York law is equal to 100% of any back wages being owed, and it goes back likewise for the full 6-year statute of limitations period, as well as any potential penalties if it's the DOL bringing an enforcement action or an investigative finding, an administrative finding, where potential violation, record-keeping violations, including credit notice violations, can be met with monetary penalties. On the slide, you'll see a sample pay notice for the hospitality industry. This includes those line items which I just provided, identified. This is a form that one can use. You certainly cannot go wrong as an employer by utilizing the form that's prescribed by the New York State Department of Labor. It's available on their website. It's not necessary that the form take this exact format, but again, it's probably best practice to make sure that you're hitting all of your line items. I'll just, as an aside, mention that New York maintains the New York Wage Theft Prevention Act, which also has its own notice requirements that must be disseminated at the outset of employment. That's under New York Labor Law Section 195.1. And there's a variety of information that must be provided, some of which overlaps, of course, with the sample pay notice for the hospitality industry, but actually goes beyond that in terms of the information that must be provided. So this applies to both the hospitality industry employers, home health care employers, and all other industries that operate and employ employees in the state of New York. On this next slide, as I've been indicating, you'll find the various tables that apply to tip food service workers in New York State. Very similar to the minimum wage schedule, which Nancy discussed earlier. This schedule pertains to those tipped food service workers who are employed in New York City, and this would apply based on the threshold as whether you're considered a, quote, large employer or small employer, and that's based on whether one has 11 or more employees or 10 or less. And you'll see that changes, as Nancy pointed out, on December 31st of each year, but they're slightly off from most other states that begin on January 1st, so be mindful of that. Again, we result in a very small violation, but better to make sure you get it right off the bat. You'll notice that there's on the top portion of the table on slide 12 are the cash wage threshold that must be paid by the employer, and then bottom is the amount of tip or the maximum tip credit for each of those individual for each individual who's a food service worker, and so those amounts in each corresponding table should equal the minimum wage, and that's how you get to those various amounts. On the following page, you'll be quite similar to the tipped food service worker is the same table for tipped service employees. So as you can see, as we've been discussing throughout this webinar, that the hospitality industry regulations are hyper-specific and technical. So it's very important that you get the definition right as to what employee falls under which definition of tipped service employee versus service worker, because the tip credit and cash wage is different. And so just be careful with that, and be sure, again, to consult the wage order, and if there's any doubt whatsoever, speak with internal or outside counsel about that. That's definitely something that EDG handles on a regular basis. Always better to be safe than sorry and get it correct and not have to make the correction after the fact. Here's entirely, I want to spend a little time talking about service charge issues or administrative fees under New York law. This has been an area that has resulted in a good deal of litigation. I've handled a good amount of litigation in New York for certain employers or clients who have to deal with service charges that usually go hand in hand with banquets, special functions, package deals, anywhere where there is a specific line item for administrative fee or service charge that's added to the customer's bill. That could displace gratuities or not. New York, though, is quite specific. The origin of this is a case referred to colloquially as World Yacht. It was, I think, going back to the early aughts where there was a service charge added to a line item at the bottom of a banquet. The question was, is that service charge a gratuity, or is it a charge that can be kept by the house, by the employer? It's been codified in New York Labor Law Section 196D, and the law prohibits employers from, generally speaking, demanding or accepting or retaining any part of a gratuity. And we covered that in the preceding section. It's the idea that only one employee who qualifies to receive, pool a tip or have a tip credit taken against his or her wages must keep that gratuity. Cannot be kept by the employer, cannot be shared by management, cannot be shared by the back of the house. There's a rebuttable presumption under New York law that a charge that is for food or drink is considered a gratuity unless indicated otherwise. Charges for banquets, special functions, or any other package deal or events where there is service charge must be clearly identified as to what it is, so that the customer is notified that that charge is not a gratuity. Now, the interesting part about this law is that the standard is judged by the reasonable customer. That's not the employee. So the customer who is signing at the bottom of that check or receipt and sees that service charge has to have that understanding whether or not it's a gratuity. And if it's unclear, it is presumed to be a gratuity, which is why it's incredibly important that employers make this crystal clear. In fact, the hospitality wage order goes a step further and is incredibly prescriptive with respect to the language that must be included on invoices or bills or contracts listing prices as to what is adequate notification that a service charge, is not a gratuity. As this slide states, and it's restating the hospitality industry wage order, it must include a statement in the contractor agreement that the charge is for the administration of the banquet, that it's not purported to be a gratuity, and that it will not be distributed as a gratuity. The hospitality industry wage order actually goes so far as to state that it must be in a font size that is similar or the same as the surrounding language, and in no event smaller than 12-point font. It's incredibly specific, and unfortunately I've seen firsthand where there can be liability where there is the wrong font size or the wording is not exactly as that indicated by the hospitality wage order. So it's incredibly important that you have this language in all the documentation that's going to the customer, whether it's a contract at the outset of, in this rather banquet, whether it's with respect to any menus that contain the pricing or else for that matter. And it's not really limited just to banquets in the traditional sense. It could be, for example, for large parties where there's an automatic charge that's assessed for parties of 6 or more, as many of us have seen the employers have potentially instituted. So be mindful of that. Wherever a service charge is utilized, or an administrative fee, or whatever its comparable charge is, be sure to consult the hospitality wage order and interpretive guidance so that you have the correct prescriptive language. This next slide, you'll see just a couple of scary examples of how service charge litigation, which is often brought as class actions under New York law, have resulted in significant settlements. This is sort of just the tip of the iceberg. I mean, in terms of just the amount of litigation over this, and with respect to the numbers, this is a small sample. It's very punitive. Gratuities that are not properly paid to employees is taken very seriously by the Department of Labor and by the courts. And gratuities under the law are considered wages. And so to the extent that those gratuities are wrongfully or even, quite frankly, mistakenly withheld from the employee as wages, legal damages can be assessed on top of that. So again, to the extent that there's a failure to distribute a service charge which was purported to be a gratuity because the customer wasn't properly notified as to the characteristic of that service charge, it would be the value of the service charge plus potentially up to 100% in liquidated damages. That is incredibly punitive, and what I haven't mentioned yet about the litigation aspect under New York law, similar to the FLSA, is that it's a fee-shifting statute. So to the extent that it's litigated and there's a judgment or even a partial judgment, the plaintiff's reasonable attorney's fees shift to the employer. That make it incredibly punitive to try to challenge these lawsuits. So it's incredibly important out of the box to get this right, and to take a little extra care and time to make sure, for example, with respect to service charges, that the prescriptive language is properly used and it's put on all the documents. For matters such as the tip credit notice, that the notice is consistent with all the requirements under the New York labor law, comparable to the form which is contained in one of the previous slides that the DOL issues. There is a need to correct it after the fact or potentially deal with an allegation or claim, whether formal or otherwise, that there has been a technical violation. I've seen, unfortunately, in my practice in litigation, where there's just a tremendous amount of liability that follows technical violations or basically innocent foot faults by employers. At this point, we're going to turn it back to Nancy, who's going to talk about spread of hours, call-in pay, and uniform maintenance requirements.
Thanks, Jeff. So we're going to first talk about spread of hours issues particular to employees in the hospitality industry. So the concept of spread of hours refers to the duration of time between the beginning and ending of the workday. And we're thinking about not just the shift where someone is scheduled to work, but practically, from the beginning of the day when they start working to the very end of the day when they stop, even if there are breaks in between. So classic example is I have written here, someone who works morning shift from 7 a.m. to 10 a.m. and then an evening shift from 10 p.m. to 6 p.m. For this employer, they're only working 6 hours during the day, but the spread of hours is 15 hours when you think about it from 7 in the morning to 10 at night. So what happens when a spread of hours is large? Well, under the hospitality wage order in New York, when a spread of hours exceeds 10 hours, and the employee works in a restaurant or an all-year hotel, then the employer must pay an employee a penalty, essentially. It's a 1 hour at their basic minimum wage for the fact that they are having a spread of hours greater than 10 hours. As it's defined here, spread of hours is the working time plus time off for meals plus any of those intervals off duty in between. Where in this example, we would say from 10 a.m. to 7 p.m. it's time that is off, but it's counted within our calculation. So every day an employee is working and the spread of hours exceeds 10 hours, the employee will receive 1 additional hour of pay at the basic minimum hourly rate, which is what we talked about at the very beginning, the minimum wage, which differs between what type of work the person's doing and where the person is located within the state. Importantly, the additional hour cannot be offset by any sorts of credits for meals or lodging provided to the employee. Additionally, when we're thinking about this additional hour, it's almost treated as a penalty, which is helpful in that employers do not need to include this additional hour when calculating the regular rate of pay to calculate overtime pay for the week. You would, in that instance, still only count the hours actually worked. So this is a little bit different than when we think about spread of hours pay in other industries. As we talked about, there's all the variety of different wage orders. In the hospitality wage order, there's no offset if an employee makes a certain amount of money in the week. So in other wage orders, if employees make more than minimum wage and they're essentially receiving enough money that would cover this spread of hours penalty, then an employer is not obligated to provide the penalty pay. But in the hospitality industry, there's no such offset. If someone's working spread hours more than 10 hours in a day and they're in a restaurant or an all-year hotel, the employee will receive that 1 hour of pay. So we're going to move on and talk about one other unique thing from the hospitality order, and that is call-in pay requirements for hospitality industry. And again, this is different than what we see for call-in pay in other industries or within different wage orders. So call-in pay refers to wages that need to be paid to an employee showing up or reporting to work. Sometimes this is called reporting to work pay on a certain day, and they're sent home. Maybe the employer does not need that employee to stay for the entire shift. And in this case, an employee will receive a set amount based on the number of shifts that the person is sent home for. So this is used in the hospitality industry because in other industries, the amount of call-in pay that someone receives is going to be very different. So if someone is out for lunch, if they show up and they're sent home for a single shift, they're eligible for 3 hours of call-in pay. For 2 shifts totaling 6 hours or less, they will receive call-in pay for 6 hours, and for 3 shifts totaling 8 hours or less, they will receive 8 hours of call-in pay. So this, again, as we talked about with the split hours, cannot be offset by certain credits for meals or lodging that's being provided to the employee. The only types of credits that can be applied to call-in pay is for hours actually worked, the tip credit. So if someone's got a 4-hour shift, they show up, they work 2 hours, an hour, after hour 2, they're sent home. In this instance, someone's being sent home for 1 shift, so they're entitled to at least 3 hours of pay for that day. The 2 hours are hours that are actually worked, so the employer can apply the tip credit in that instance, but hour 3, the tip credit cannot be applied, and so the employee needs to be paid at least the basic minimum wage, which, again, as we talked about, is based on those charts that we saw in the first couple of slides here. So just a bit different than we think about the other industries and can get a little bit tricky. Another important thing to think about here is only requires this penalty pay for a regularly scheduled shift. So that's a fixed repeating shift that an employee would normally work same day of each week. This does not apply to hours scheduled for something that's going to change from week to week. So just something to keep in mind when we're thinking about when this applies. Finally, one other note about call-in pay. There have been regulations issued by New York State for the miscellaneous wage order, which is the wage order that applies if you are not subject to any of the other named wage orders. And the regulations that were proposed last November by the state with respect to call-in pay would really change the way that a lot of employers need to manage their practices and would increase the definition of call-in pay beyond just having someone report to work and being sent home. In this instance, under the proposed regulations in the miscellaneous order, it could apply to a variety of other situations. So keep an eye out if you have employees in one of those industries that the miscellaneous wage order applies. We'll make sure to keep you guys updated as those regulations move along in their process. And finally, we're going to touch base quickly on uniform maintenance pay under the hospitality wage order. So this is an amount of money that needs to be provided to the employee for maintaining a uniform that an employee needs to work in order to perform as part of their job. So uniform clothing that the employer requires the employee to wear that would not normally be considered part of an ordinary wardrobe. So it doesn't have to be a full outfit. It could be a shirt. It could be a single item of clothing. If an employer is requiring this uniform, then an employer needs to provide certain pay in order to keep up with the maintenance, including laundering the uniform, washing, dry cleaning, any sorts of repairs or alterations. Amount of pay is going to depend on, I talked about again, based on where the employee is located. So there's different rates based on whether someone's in New York City, someone is in Long Island or Westchester County, or elsewhere in the state. It's going to also depend on the number of hours worked per week by that employee. And so there's a set amount that needs to be provided. So we can certainly help provide that information to you if you have employees who are wearing uniforms And, just something to keep in mind if that is part of what the requirements for your employees.
And just to add, and this is sort of an aside, but I'd be remiss as a wage hour practitioner if I didn't mention it. Uniforms in the workplace can be a tricky thing. Just be mindful of not just the legal requirements under New York law for uniform maintenance pay, which Nancy just described, which are set forth in the hospitality regulations, but also generally speaking, and this is really more of a federal and state issue of donning and doffing. Very important to keep in mind that where employees who are put on and taking off a uniform that's elaborate enough or really, frankly, more intricate than just perhaps, for example, an apron or a jacket, really is changing in and out of clothes at the beginning and end of the shift, could potentially be required to compensate those employees for the time that they're spending donning and doffing those items that are required by the employer in the workplace. It's something, again, just tying on an apron or putting on a hat or something like that, which can be done on the floor of the establishment. I think that's perfectly fine. We're really not talking about any quantifiable unpaid time, though if you're talking about donning and doffing that requires being in a locker room where an employee in his or her discretion may spend different amounts of time putting on and taking off those articles of clothing before and at the end of the shifts, depending on the amount of time at issue, the best practice often is to make sure that those employees are clocking in first before changing into the required clothing and then clocking out, but only after the clothing is removed at the end of the shift and the employees go home in his or her own street clothes. So I wanted to add that just as an FYI, that really goes hand in hand with uniform issues, which Nancy just described. At this point now, I'd like to turn it over to Shira, who's going to switch gears and talk about home health care practices and issues under the FLSA and New York law.
Jeff just said, I'm going to discuss some of the wage and hour issues which are specifically impacting both workers and employers in the home health care industry. So in the last few years, we've seen wage and hour claims by home care workers on the rise, and there's been an increase in filings by employees claiming that they either were not paid for all time worked and or that they were denied overtime pay. The lawsuits focus on whether or not these employees were working, whether workers are in fact employees or whether they're independent contractors, whether they qualify under what we will discuss later and is referred to as the Companionship Services exemption, and where the worker was hired by a staffing agency or a third party, whether joint employer issues exist. So as a general rule, under the FLSA, most home care workers are employees and not independent contractors. Home caregivers are considered live-in caregivers who, in fact, reside with the person that they're working for. They live with the client for more than 120 hours per week. The Department of Labor takes the position that 8 hours per night of sleep time can be excluded from hours paid. However, employers are required to pay if there is an interruption in the worker's regular sleep hours, and they cannot deduct sleep time if the caregiver is given less than 5 hours of sleep. So I need to turn to what I just mentioned, the Companionship Services exemption. Under this exemption, employees who provide home health care services for individuals who either because of age or infirmity are unable to care for themselves may be exempt from wage requirements depending upon the type of services that they provide and the nature of the working relationship. If an employee falls under this exemption, then they do not need to be paid minimum wage or overtime. Effective January 1st, 2015, the FLSA revised its regulations, which define companionship services, and significantly narrowed the definition of companionship services. The reason behind this is because the exemption is geared toward individuals, workers who are helping individuals with disabilities or the elderly to continue to live independently in their homes, so if they need to go to institutions or other residences where they can be cared for. And so it's geared towards individuals who are helping these people participate in their communities, and they focus on whether the worker is providing what's referred to as fellowship and protection. So they accompanying the person outside of their home to make sure that they're safe. Are they helping them engage in activities such as conversation, reading, games, crafts, taking on walks, errands, and social events? How do you determine whether the companionship services exemption applies? Well, first, under these new regulations, we have to ask, is the employee providing care as defined by the exemption? The rule defines care as assisting with daily living activities such as bathing, dressing, grooming, feeding. And to qualify under the exemption, home care workers can spend no more than 20% of their total working time in a work week assisting with personal care. Look at is whether the worker is performing ethically related tasks. They want to qualify under the exemption perform any of these because they are tasks that are normally done by a nurse or a certified nursing assistant. And the thing we're looking at is the rule limits household work to only those benefiting the elderly person or individual with disability or illness. So if the workers provide any household work that benefits any other member of the household, doing their laundry or cooking, that employee would no longer fall under the exemption, and he or she would need to be paid a minimum wage for overtime for work week. Next, we're going to discuss the live-in domestic service employee exemption. The exemption applies to home care workers who either live in the same home with the person they work for permanently or for an extended period of time. And the FLSA gives those individuals special treatment. In determining whether the exemption applies, the FLSA distinguishes between whether these individuals were hired directly by the consumer that they're working for, or they were hired by a third party, such as a home care staffing agency. If the worker was hired directly by the consumer, then they would fall under the exemption, and they would be entitled to at least the federal minimum wage for all hours worked, but they are not entitled to receive overtime pay. However, if those home care workers are solely or jointly employed by a third party, such as a staffing agency, they have to be paid at least the federal minimum wage, and they are entitled to overtime pay for all hours worked by that third-party employer, and they cannot claim that exemption. Problems that we see, and what's led to a lot of filings, is where an agency and a consumer can be considered joint employers, meaning that this worker is employed by two or more employers, and so both employers can be responsible individually and jointly for compliance with certain statutes. So if you look at the example here, let's look at the first one. Example, Stanley called local home care agency, which married a worker to come work for him. Mary moves out of her apartment, she moves into Stanley's home, and she provides him with daily care. The two agree on her work schedule and what tasks she's going to perform. However, local, the agency, is the one that sets Mary's rates. In this situation, both local and Stanley would be considered Mary's employers, and they both have to make sure that she's receiving at least the federal minimum wage. However, local is responsible for ensuring that she receives overtime pay because only Stanley, the individual, can claim the domestic service employee exemption. Contrasted to the next example, Stanley directly hires Mary after getting some names from a registry, and the two of them agree on her tasks, her rate of pay, and even though she lives with him, her only employer is Stanley, she's only entitled to the minimum wage, but not required to receive overtime pay. We're going to discuss the 24-hour sleep time issues that are for home health care workers. So historically, in what is referred to as the 13-hour rule, the Department of Labor has required residential or employees who live with the consumers to be paid for only 13 hours of every 24-hour shift that they work, provided they're given 3 uninterrupted meal breaks and 8 uninterrupted hours of sleep. So behind that is that they believe that workers should not be paid for time when they're eating or sleeping, despite the fact that they may not be choosing where they're eating or sleeping. In the year, however, several court cases have challenged the 13-hour rule's application to home care attendants, and 3 New York State Appellate Division decisions have refused to give deference to the Department of Labor policy and guidance, and they've actually invalidated the 13-hour rule. Let's take a look at those decisions. So decisions, 1 in the first department and 2 in the second department. The divisions basically determined that home care aides working for a third-party agency are not residential, meaning that they do not live on the premises of the employer, and therefore the employer cannot take advantage of the 13-hour rule. The implication of these decisions is vast because it means that these agency defendants are now liable to pay that non-residential live-in aide for every hour of a 24-hour shift. Now, these decisions are on appeal. If they're upheld, the decisions could expose home care agencies to significant liability for minimum wage, overtime, and spread of hours pay from employees who qualify as non-residential while they were employed for 20 hours as home care attendants. In response to these court decisions, the New York State Department of Labor adopted emergency regulations because they were worried that this would eventually lead to the collapse of the industry. So now the New York Department of Labor provides that employers are not required to pay home care aides who work 24-hour or longer shifts for their meal and sleep time, and so they're able to exclude the home aides' normal sleep and meal hours from times that they worked. I will turn this back over to Jeff.
Thanks, Shira. So we're going to shift a bit more generally to independent contractor classification issues. And I say more generally because it's not a New York-specific issue. As many of us know, this is a national concern. I'm usually going to be focusing today on independent contractor status, classification, perhaps misclassification, under the federal law and its regulations and how they're generally interpreted by courts across the country. That said, and this is an important caveat, is that many states have instituted their own tests, many times interpreted through various courts in various states or legislation in coming up with a sort of restrictive test where almost the assumption is that, or assumption is that workers are employees, generally speaking, and few are truly bona fide independent contractors. For example, we have a recent California case, Dynamex, which is quite stringent with respect to its application of contractor classification, or its analysis, I should say. In New York, there's a comparable test to the test that's utilized by courts when interpreting contractor status under the FLSA. One case in particular, Bainag v. Cipriani, is a case that recites certain factors, which I'm going to describe momentarily under the federal standard, which again is comparable. But generally speaking, New York is more employee-friendly, and so while it's not legislative, they're certainly in interpreting the test, courts can tend to show deference to employee classification rather than independent contractor classification. Massachusetts similarly has quite a stringent test, so it's very important that when considering contractor classification, that you, the employer, looks at or undertakes an analysis not only pursuant to federal law and regulations, but also state-specific ones, because again, which is always the requirement that the employers look at the employee protective law in the jurisdiction in which the employee is performing services. You can't just default, unfortunately, to the law or regulation that is most convenient or serves your business purposes. You must look to what is considered to be most employee protective. There's been some interesting developments under the new administration with respect to independent contractors and how they're classified and analyzed by the U.S. Department of Labor. Under the Obama administration, the Gunzenhauser administrator, David Weil, had issued an interpretation, which is essentially a white paper, which set forth the factors that the employers in the court should consider when determining whether a worker is in fact a bona fide independent contractor or not. And that follows the then DOL's tagline that most workers are in fact employees and not independent contractors, unless those workers are in fact in business for him or herself. And the interpretation, while not given deference such as a federal regulation, was something that the DOL relied on in the course of its own investigations and enforcements that they pursued in federal court with respect to FLSA compliance, which would include independent contractor classification. Now, I always say this to clients that classification, whether it's with respect to independent contractors or exempt or non-exempt employees, in and of itself is a violation of a federal or state statute. That violation will be with respect to overtime or perhaps tax benefit or tax consequences or benefits-related issues. It's the ultimate classification or misclassification that could lead to potential liability because certain benefits, whether fringe or overtime or tax-related, will flow from whether one is classified as an independent contractor or an employee. Going down whether one receives a 1099 or is a W-2. It's important to make sure, like all these other compliance issues, that you take a hard look at how your business is utilizing workers, how they're being classified, because there might very well be a good business justification to utilize independent contractors as opposed to being an employee. But from a legal perspective, there could be significant compliance issues that cannot be ignored, should not be ignored. Similarly, as I've heard from many clients, workers often like to be considered independent contractors. They want that classification. They want the flexibility in their workday. They may have other professions or endeavors which they're pursuing, which would want them to maintain that independent contractor status and not feel that they're tied down as a traditional employee of a given job, or in a given job, I should say. And they may enjoy certain of the tax benefits as well. But you truly disregard that, and you should not take your cues from the workers. It really has to be an employer-mandated analysis and policy with respect to how workers are classified. As I mentioned earlier, the interesting development is that in June 2017, the Trump administration DOL withdrew Dr. Weil's interpretation under the Obama administration with respect to independent contractor misclassification and didn't replace it with other guidance, but basically took it away from the DOL for enforcement purposes and frankly all other purposes, meaning the DOL can very well go into court in an enforcement action and rely on that interpretation to argue its case that a particular worker or group of workers were wrongly classified as independent contractors, which I think is a big boost for for employers, and it's a step in the right direction, giving employers a little bit more flexibility when making business-related decisions on classification for their workforce. In addition to that, this past July, the Wage and Hour Division of the USDOL issued a field assistance bulletin with respect to caregiver registries to determine whether or not they're considered the employer of a caregiver. That, again, is a interpretation with respect to contractor classification in this particular subsector, which we think is clearly relevant for the purposes of our webinar here today. That particular FAB was the Administration's first substantive guidance on contractor classification. First part I sort of want to talk about, many of you are already aware of this, but there is a standard for determining that the courts utilize for determining whether a worker is a bona fide independent contractor or an employee of the putative employer. That's often referred to as the economic realities test. That finds its origin in the Supreme Court case, US v. Silk, and it talks about a sort of non-dispositive totality of the circumstances test, a six-part test. There can be other considerations to determine whether a contractor is properly or correctly classified. In no particular order, the first part or factor is called integrality. The extent to which the work performed by the worker in question is integral to the employer's business. If it is, there's likely going to be a finding that that worker is an employee. One example I often like to give is an employee or a worker who's performing services in a software company, and that worker is being called in for a discrete project to paint the walls of the office, and not actually working on software, not necessarily displacing any of the other employees who are employed to work on software, or a function that is integral to the software company's business. That worker is likely going to be considered, at least for this factor, as not being integral and will not support employee status. However, if you're potentially bringing in an independent contractor to focus on a system or function that's directly related to software development or software sales or whatever the nature of the underlying business is, and that worker is essentially, similar, if not the same, to those who are employed by the company, then there might very well be a finding, at least again for the integrality aspect of or function of the economic reality test, that worker more clearly resembles an employee. As I mentioned before, it's a totality of the circumstances test. Not one factor is dispositive. The courts will look to whether, in an overwhelming state, the factors suggest independent contractor status or employment status. It's quite objective. You will see courts going in various directions, even with comparable facts. So it's never completely clear. It often is real best practice and policy to work with in-house counsel, outside counsel, to take a hard look at whether it's a systematic audit or at the outset of the relationship, to determine whether classifications are appropriate, conservatively applied, so that the employer can make a well-informed decision, understanding the potential risks as to whether he or she should be classified as an independent contractor or employee. The second factor is with respect to profit and loss. Are the worker's skills going to affect one for profit or loss? Meaning, in other words, does the worker in question earn a day rate or a salary or an hourly wage, which is predictable, which is akin to the compensation remuneration that a worker would receive as an employee of any given company, as opposed to whether there is payment that takes into account, for example, a quote or a bid, where the worker in question, the putative independent contractor, has his or her own particular investments, and we're going to talk about that, which is a separate factor, which might count against the profitability of the given venture or contract or project. Also with respect to whether the worker in question employs others, so that the independent contractor who has to pay other individuals might cut into the profitability of a particular project based on what that contract or arrangement pays. But if it's more predictable and it more closely resembles a wage or a salary for not necessarily a discrete project, but maybe on an open-end basis, that will more often reflect an employment relationship rather than independent contractor relationship. I mentioned before, the third factor is investments in facilities and equipment. Think of, for example, hardly hospitality, but someone who's in the drywall business, and they have to have various machinery and equipment, such as various hydraulic lifts, perhaps handheld tools and other materials, ladders, and etc., are necessary to perform the job. And how significant are those investments as opposed to someone like an employee who just shows up to the job with his or her own skills and abilities and performs the work, and the equipment and facilities are provided by a putative employer. In that instance, again, it's more reflective of an employment relationship because there really isn't any equipment or investment being made by the worker in question. The fourth factor is skill and initiative, and so this sort of relates to whether the worker in question is being specifically utilized for a unique, discrete skill which a putative employer is relying on and utilizing can't otherwise be accomplished by an employee. I go back to my case where a software developer isn't necessarily going to be employing a professional painter to paint the offices or perhaps perform or do landscaping around the building. And so in those instances, it would be reasonable for the putative employer to go outside to the service that provides those aspects that are not integral, as we discussed before, to the business. Someone to paint the walls. And it's expected that a software employer is going to have a full-time painter. And actually, as I'm discussing these factors and discussing this example, these factors, the economic reality test, go sort of hand in hand. Everything sort of plays within one another. It's very fluid, and you tend to get an idea, pictures being painted, if you will, as to whether the bona fide contractor is in business for him or herself. Is there a reliance on the putative employer for the contractor's livelihood, or it's really just a discrete project, job, assignment, where the next day, the next week, the next month, that same contractor is going to go perform for others. Part of that is, as I was just alluding, is the permanency of the relationship. Is the engagement on an open basis, or is it discrete in nature? Again, going back to the painting example, is it something that's going to be a one-off, or is it something that's really going to be in perpetuity? And that sort of goes to show or reflects, an open-ended basis, something akin to an employment relationship. If there's no hard stop, discrete, clearly discrete alignment that the worker in question is performing, then it's likely going to reflect more of an employment relationship for purposes of a factor. And lastly, we talk about control. This is very overarching, and many courts often start with control and really look to control as the overriding factor to determine whether or not the worker in question is an independent contractor or employee. Control, nutshell, means, well, does the worker, is he or she given a specific task and then sent off to determine whether or not, using his or her own discretion, how that task should be carried out? Or is the putative employer truly controlling, supervising, directing all aspects or many aspects of the actual project and the relationship? It goes beyond just actual performance of the work. It was also to setting the pay. Does the putative employer dictate to the worker in question what that pay rate is going to be, or is it going to be negotiated, or is it going to be quoted by the independent contractor? Those issues are ones which are looked at closely by the courts, by the Department of Labor, to determine, whether there is, enough control or overwhelming control, which would clearly suggest an employment relationship. Before this past June, there was or July, there was a field assistance bulletin that was set forth with respect to caregiver registries. I'm just going to run through this quickly because we have a little additional or separate topic area to cover, and I know that there's been a few questions that have come, and we're going to try to get to them if we can. And actually just take this moment to say that if we can, because of time constraints, we'll certainly do our best to reach out to you and provide that by email if you want to provide that information. Amanda will just give you directions at the end of the program as to how to best do that. With respect to the field assistance, then to determine again whether these registries are employers under the FLSA, the bulletin looks to factors such as whether conducting a background and reference check is something which is going to indicate employment status. Came out, like many of the other totality and circumstances factors, that in and of itself is not going to indicate whether a registry is an employer. Hiring and firing. Registries may participate in initial determination of such requirements. The ultimate decisions regarding hiring and firing should rest with the client with respect to whether or not there's a finding of employment or contractor status. If the registry controls any aspect or many of the aspects of hiring and firing decisions, that very well indicate that there is an employment relationship. Similar to scheduling and assigning work. This all is part and parcel of the control that we just discussed under the more traditional economic reality analysis, and this is really just an application of that, controlling the work, the scheduling. It's really the client, the caregiver, who's managing the process of the workflow of the assignment. It should not flow through the registry because that in and of itself is going to reflect an employment relationship. Moving to the next slide, and again, consistent with what we've been discussing, set the pay rate, payment of wages, tracking of the hours. These are all things that should be controlled to avoid a finding of sort of employment status between the registry and the actual caregiver. You want the client to control that, or the caregiver, him or herself, to do that. The more the rate is involved, the closer one might find there to be an employment relationship. So going to shift topics, because we are running out of time, to best practices for tracking hours. And Nancy's going to present on this, and I just to sort of tee this up, what we're largely talking about here is best ways to make sure that employers are capturing all the hours worked by the actual employees. Why is this important? Because there's an exceeding number and growing number of lawsuits year after year, as well as federal and state DOL investigations with respect to off-the-clock work. Work is not captured, formally or informally by the employee or employer. Under law, federal and state, New York State, it's the employer's responsibility to maintain an accurate and contemporaneous record of all time worked by employees. This includes time worked during a lunch period or time worked at the end of a day. And in the absence of that, the employee is permitted to actually go back and reconstruct his or her hours and go forward in court and present that evidence. And then the burden is back to the employer to disprove it. And in the absence of records, it's very, very difficult for employers to prove that an employee did not actually work the time he or she claimed to have worked. So not taking over the entirety of this segment, I'm going to turn it over to Nancy to talk about some of the best practices.
Thank you. So really, as Jeff was saying, the key part of this is ensuring that you're putting together a system that works for your workforce and your employees. One of the first things to be able to set this up is ensure that employees know their schedule. If an employee is working a certain shift, then they have timely notice of that shift will be, there's shift reminders, or an easy way for someone to be able to access and review the shift and any changes. Next, it's going to be really important to have a system that tracks the time, and this can be in a variety of different ways. This could be a physical sign-in, sign-out sheet that is, either by an entrance or in a break room or in a locker room, where people are required to sign in when their workday begins, sign out for any meal periods or any extended periods of time between shifts, and sign out at the end of the shift. A way to manage this is through an electronic system. There are apps that employers can use that employees can, sign in and out of either on, a computer or an iPad that's in the workplace, or have one that's even on the employee's phone to be able to clock when their hours are worked. It's really important that the employees know when their shift is set to begin and when they're actually performing work. So we often will hear from clients that employees will show up very early because they aren't sure what's going on with traffic, with train or subway delays, and they'll get there early and sit there and eat breakfast. And they want to clock in for that. And it's an hour before the shift is set to begin. If the employee is not performing work, they should not be clocked in. If they're showing up and not performing any work, that should not be the hours they are working. So it's important also that employees understand the policies and understand when it is appropriate for them to clock in. Now, if they're showing up 15 minutes early and working, they'll need paid for that time. But that can be an issue that's resolved through management about talking to the employee when is the appropriate time to begin the work for the day. If your workforce has access to remote access or smartphones and they're checking their email or responding to clients during the evenings and outside of the normal working hours, it's important, as Jeff mentioned, that to capture all of this time, we call off the clock work. And there are some applications out there that can track any sort of time that's performed outside the normal working hours, if it's being spent on opening and reading and responding to emails within the employer's email system. So these are a couple of ways for employers to think about how best to track and monitor their employees' time as they're working. And I think at this point we want to open up the floor to any questions that may come in about everything that we've talked about over the past almost hour and a half.
So the question we have is, I'm going to quote, my understanding is FLSA does not consider the hours payment to be a penalty and excludable from the regular rate for OT purposes at any federal case law. So hours is a New York-based requirement. It's actually not federal. So if you're not employing employees in New York, then it's not a requirement under any other state law. So with regard though to hours payments under New York law, may have been referred to as a penalty. It's not a penalty in the traditional sense as the DOL, New York State Department of Labor, might impose for such, say, a record-keeping violation. But as Nancy said, for overtime purposes, it need not be included, and I think that might be why there was a reference with respect to it being akin to a penalty. And I think that might be the only question. Oh no, there is another. Is there any requirement in New York that requires an employer to reimburse or pay for part of cell phone if it requires managers access email or reply to group texts from personal devices?
So that's an interesting question. There are some states that explicitly require that anything that is purchased or used by an employee in order to perform work must be reimbursed. So California has one of those laws, pretty strict, that if someone's using their cell phone, you must reimburse at least a reasonable portion. New York doesn't specifically have that exact requirement, but it is something that many employers tend to do if they're going to require an employee to be able to access email or text messages in order to be able to perform their work. It's normally an incentive, or if an employer does not want to pay for an entire cell phone bill or a large portion of it, they can even consider getting a device that has very limited capability to be able to give to the employee.
Great. I don't see any other questions listed here, but we do have a minute or two, so if you want to quickly type one out, by all means, we'd love to respond. If not, and a question occurs to you later, or you'd rather ask it offline, Shira, Nancy, and I would be more than happy to field those questions, and Amanda's going to take it over here and provide the logistics on how you could accomplish that.
Thanks, and thank you everybody for joining us today. This will conclude our webinar. In approximately 2 to 3 days following the webinar, we will communicate the availability of the recording and the PowerPoint materials. We thank you again for joining us and hope you have a wonderful day.